I'm Dean Alexander from Alexander Lawyers, and I'm here at the Essex Property Network, run by Cyril Thomas, and he's asked me to also do a brief talk about lease options and the myths behind lease options. Firstly, the term lease option is quite misleading. That's what's commonly known as amongst investors. We often talk about lease options. However, when we're actually dealing with a lease option, as it's commonly known, what we're talking about here really is about controlling a property via a management agreement. There's actually 3 agreements that we draw up when being instructed by an investor to help with a lease option, and they are a power of attorney is the first thing. Secondly is the management agreement, as I said, and thirdly is the option agreement itself, and it's really important you get proper legal advice to draw up all of those documents to make sure that it's done correctly. The second point I've been asked to talk about is the difference between a delayed completion contract and an option agreement. Again, I want to stay away from terminology because we hear all sorts of phrases like instalment contracts, delayed completions, conditional contracts, long-stop completions. There's so much terminology thrown about. Basically, if you are putting together one of these types of arrangements, the question is, should I be doing an option arrangement or should I be doing a contract? Generally speaking, our advice is, and say generally speaking, our advice is that you enter into a contract which is more robust. However, in saying that, without wishing to sound like a typical solicitor, it does depend on every single case. We did come across some investors one week, I think, have been on the same training course where they were advocating the completion contracts, and we're all for that because, as I just said, generally we think they are better. But we had 3 different inquiries from the same, as a consequence of the same weekend course, where they wanted to do contracts, and when they came to see us and we discussed the detail of their particular deals, we actually advised them that an option route was better. So there you go. You can't really generally advise on it. It does depend on each case. Right. There are 2 main sort of variables really in deciding when you're setting up your arrangement whether it's going to be an option or a contract, and that is basically how much deposit or money up front are you paying, and if a lot of money is being paid, then you might prefer a contract. As I say, it's more robust. On an option, it's money that is being spent. You're not going to get that money back, so there is a risk there with an option if there's a lot of money involved in the deal. And the second key variable to this, I would say, is considering the stamp duty land tax. The downside of the contract is that if you're above the threshold where SDLT is payable, that's that stamp duty land tax, then you may not want to pay that tax. So it may be better to do an option where generally the tax is not payable on an option. So there are 2 things to consider when you're weighing up an option and a contract. One of the things to look out for is sandwich options. This is something which I'm not a big fan of. I'm not saying don't do them, but like with any of these contracts, you should get proper legal advice. And if you are going to take any shortcuts, this is something that you can't really afford to take shortcuts on. Do get a lot of investors coming to us talking about sandwich options, seem to think that they're very straightforward. Couldn't be further from the truth. Sandwich options are actually one of the more complicated structures to set up. The timing of the agreements and how you deal with it is critical. There are some time traps and you can be caught by FSA regulations, so make sure you take proper advice when it comes to dealing with what people refer to as sandwich options. We need to look at whether the head option allows for the head arrangement allows for the sub arrangement, and whether powers of attorney are drawn widely enough. There's a lot to consider. They are more complex, and you really must take legal advice when dealing with one of these types of structures. The other myth I'd like to just mention, that a statement that comes up quite a lot is when you hear people talking about buying a property for £1. Obviously, that's a bit of a misstatement, to say the least. more accurately, it would be controlling the property for £1 and actually buying the property for £1. Obviously, you've also got your legal fees, all your usual fees to consider. You can, of course, yeah, it's possible to control a property by using an option arrangement for just £1, but you do need to look at the two scenarios where you get one where there's a lot of equity in the deal and one where there is no equity in the deal. Where there's no equity, the £1 down deal, as people sort of refer to, can possibly work. If there's a lot of equity in the deal, that's a different situation. You do need to look at, make sure there's a win-win situation, and the seller is getting something out of the deal, and you're not just trying to get every last penny out of the seller. Otherwise, you can have a problem with an unfair contract, and then you could have an argument from the seller that it was unfair later on, and then come up against a lot of problems. So you do need to give it some thought. The statement of buying property for £1 is be aware of anybody that's coming out with statements like that. There isn't anything, any such thing as a free lunch, as they say. One of the other myths that we come across is people asking just if anyone's got a standard agreement. Isn't really such. I'm not quite sure what they mean by that. I think sort of investors trying to cut corners and crib agreements from either a solicitor or from another investor. I have seen typical one-page option agreements, for example, flying around, which aren't really worth the paper they're written on. Of course, we in the office, as firm solicitors, have lots of templates. We've probably got about a dozen or so templates that cover option arrangements and similar types of arrangements, joint venture agreements, contracts, for example. And yeah, of course, we have something to base a deal on, but we then have the heads of terms done, and we have to then look at tailor it into the deal. So it's not quite as easy as people normally think. And if you're not taking any proper advice and you are looking for a standard agreement that's trying to cover things, and you're trying to use that for your deal, you're going to come into problems. And we're already getting that now. We're getting people that have tried to do that have then contacted us, asking us for advice to help them out of the situation because it's gone badly wrong. We had one just recently where somebody had done their own option, hadn't done it properly, hadn't registered it, took no advice. There was £10,000 in the deal for them. They ended up instructing us and asking us to contact the solicitor to sort of persuade them or help them to agree to the agreement that was in place. And luckily for them, the seller didn't have any problem in agreeing to it, and £10,000 going across to the investor company, but it ended up being a lot of hard work and a lot of stress for the investor because they very nearly lost the deal. But we were able to help them recover that, but it was really unnecessary. So try to stay away from some of these standard agreements that people refer to and get proper legal advice.